Today we're talking about liability factors for different types of auto accidents. Hi, my name is Raul Guajardo. I'm a personal injury lawyer and we've been serving South Texas for the last 20 years. Determining whether the defendant is liable for an auto accident injuries is the first and most important factor to evaluate when assessing your personal injury claim. For most auto accident claims, this involves looking at all the following factors. How badly damaged were the vehicles involved? Did any of the drivers involved give statements to the police? Were there any witnesses to the accident? Was there any alcohol used by either driver? How were the driving conditions at the time of the collision? Did both vehicles have functioning headlights, tail lights, and turn signals? And finally, are there any defenses? For example, even though the defendant may have made an improper left turn in front of your car, were you speeding? Let's look at 6 common types of accidents and focus on some specific additional factors that will come into play in determining which driver was at fault or liable for the collision. Number 1, rear-end collisions. Rear-end collisions are no doubt the most common type of accident. Most of them occur when the stopped vehicle is waiting in traffic, waiting to turn left or right, or waiting for a light to change. The police report will frequently place fault on the moving vehicle, usually for following too closely or for inattentiveness. The driver of the moving vehicle will often admit liability at the scene to the police officer, you, or other witnesses. Keep in mind that the insurance companies usually pay considerable attention to police reports. However, sometimes carriers or their defense attorneys will claim no liability due to sudden and unexpected stopping, failure to signal when stop and turn, not yielding before pulling into traffic, or a brake defect. An experienced injury attorney will want to learn about the following specific facts when assessing the certainty of liability in your rear-end collision. Vehicle position. The other driver's speed. The other driver's following distance. And your use of turn signals. Number 2, intersection accidents. For the following reasons, it can be difficult to prove liability in intersection collisions and failure to yield accidents. A shifting story. Sometimes there is a lack of consistency between what the drivers say in the original statement to the police and the statement given to the insurance companies. The absence of witnesses. If there were no independent witnesses, it can become a finger-pointing contest, which will be won or lost based purely on credibility of the drivers. Detailed rules of the road. Sometimes the rules of the road are not easy to apply when the driver's stories shift. And finally, an artful defense can be presented to throw a wrench into a case, such as that the lines on the road were recently repainted, but the old lines were still visible, thereby confusing the drivers. Number 3, parked or disabled vehicles. A number of factors can make or break your case when you have collided with a parked, stalled, or disabled vehicles, including the reason for the vehicle stop. Did the vehicle break down? Or was it parked because the driver was intoxicated and passed out in the driver's seat? The availability of better location. Could the driver of the stopped car have found a safer location to stop? Warnings. Were there police barricades or cones making the area for some reason unsafe to stop? The condition of the roadway. Was there a big drop-off when the road meets the grass strip or unpaved land area? Your negligence. Did your phone ring and were you trying to see who was calling? And lastly, was there a statutory violation? Were you speeding or did you forget to put your lights on? Number 4, auto versus pedestrian. The overriding factors in pedestrian cases is whether you were walking in a crosswalk when hit. If not, the insurance company and its defense attorney will present a jaywalking defense, and obtaining a favorable settlement or verdict will be difficult, but not impossible. The following liability factors should be carefully examined. The reason for jaywalking. Was a mugger pursuing you or were you just impatient to get home? What's the governing traffic code? Length of walk signal at the crosswalk. Available light on the street. Visibility of clothing. Were you dressed in black while walking at night? Witnesses, including other drivers and pedestrians. The driving speed. The driver knowledge and experience. An 18-year-old driver would be viewed as less experienced than a 45-year-old veteran of the roads. Weather conditions. Was it foggy or were there snowstorms obscuring view? Mechanical defects. Did the car brakes malfunction? Impeding view. Were there low-hanging branches on an adjoining yard blocking the start of the crosswalk? Tardy driver. Was the driver of the striking car late for work at the time of the accident? And whether the victim was a child. Below a certain age, in many jurisdictions, a child cannot be deemed negligent or comparatively negligent. Number 5, auto versus cyclist. Bicycle riders are generally required to observe the same rules, regulations, and safety standards as a car driver. Stopping at signals, yielding the right-of-way at intersections, and using turn signals are as important for cyclists as motorists. The following liability factors should be examined carefully when assessing an auto versus cyclist case. Designated riding areas for cyclists. Reckless riding. Safety equipment worn. Police assessment of liability. Available light at the scene at the time of the accident. Visibility of clothing on the bicyclist. Driver, cyclist, and other witness statements. And degree of injury to the cyclist. Number 6, truck accidents. Most truck accidents cause serious injury because of the weight of the truck and the resulting force at impact. Nonetheless, truck accident cases frequently face several obstacles to successful resolution. Number 1, experienced and difficult adjusters. Insurers often use their better and tougher adjusters in truck accidents. Biased witnesses. Witnesses often sympathize with truck drivers. Number 3, dishonest trucking personnel. Trucking companies and drivers sometimes falsify or lose records that could help your case. Number 4, multiple defendants. You will possibly face several opponents, all of whom will be trying to pin some blame on you. Number 5, passage of time. Investigation must begin promptly in truck accident cases. You'll be at quite a disadvantage if months have passed between the accident and you retaining an attorney. Here are potential areas of liability that should be considered in every truck accident. Was there excessive speed by any vehicle involved? Was there a violation of safety regulations by a trucking company? Did any defective equipment contribute to the accident? Were there visibility issues at the time of the collision? Were any of the drivers involved in the accident inexperienced? Was the truck overloaded? Did improper parking contribute to the accident? Was there an unsafe turn in the road indicating road design could be a factor? If you have been in an accident and you have any questions we can answer about your insurance claim, don't hesitate to call. There are no strings attached. We can be reached at 956-318-3200.